My name is Dave Zapponi. I'm the CEO of ECHO, or otherwise known as the Educational Council of Homeowners. Thank you for participating today. The meeting will be on our community conversation will be on election by acclamation and the recall process. ECHO is a statewide nonprofit association. We're established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on the screen. In addition, slides were sent to registered participants beforehand. Please take a moment and review our housekeeping items. You should use the chat icon to report any technical issues and to communicate one-on-one with other participants. Today, we have a large audience of HOA board members. We will do our best to answer the questions, but we may run out of time before we're able to do so. It is important for you to use the Q&A feature to ask your questions. The chat feature is not monitored for questions. To help us select the most relevant, please use the thumbs up icon found in the Q&A feature. Simply click this upvote icon to select your favorite. We do answer the questions with the most upvotes first. Please keep your questions general in nature and short. Our questions about specific situations are better asked of your attorney directly, the one serving your association, or another appropriate industry professional. I will respond in writing to some questions in the Q&A feature during the presentation. Perhaps one of the attorneys will also respond during the presentations as well. All other questions will be answered during the Q&A sessions. We have 2 today at the end of each section. Please keep your questions and responses short and concise so we can address as many as possible in the time allotted. Complex questions will likely not be answered. Now, let me direct your attention to your monitor, where you will find our disclaimer. None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker, the sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. Today, we have several sponsors. Please join me in thanking them. Our Q&A sponsors are Liberty HOA Election Services and Silver Creek Association Management. We will also be giving away 2 $50 Amazon gift cards, courtesy of our gift card sponsors, Liberty HOA Election Services and Swedelson Gottlieb. You must stay to the end of the webinar for a chance to win one of these 2 gifts. Now, for a little about our speakers. Stephen Brindle is a senior associate attorney at Swedelson Gottlieb. He was born and raised in the San Francisco Bay Area. Stephen represents and provides counsel to community associations on matters ranging from operations, corporate governance and governing documents, enforcement, short-term leasing, assessments, demand letters, dispute resolution and settlement agreements, and general transactional matters. Sandra Gottlieb is a founding partner of Swedelson Gottlieb, which focuses its practice on the representation of California homeowner associations, including condominiums, planned developments, and cooperatives. Sandra's extensive negotiating skill, acquired and honed throughout years of practice, has given her the ability to work with volunteer board members, association managing agents, and opposing counsel to achieve intended results and to provide expert legal representation on association operational issues. Stephen and Sandra, please take it away.
Thanks so much, Dave. We really appreciate being here. And we are back Again, talking about elections. For those of you that don't know, we taught a session on elections last year because there were so many changes in the election laws, and we did it for ECHO. As I understand it, that seminar is available for your viewing on ECHO's YouTube channel. You shouldn't have any problem accessing it, but if you do, contact ECHO directly, because I think as a foundational issue, you might want to go back and look at that. We are going to be talking about two things this as our topics today. One is election by acclamation, and then recall and removal. And because election by acclamation is a new law as it applies to all associations, we're going to break our Q&A down into two sessions so that we really can take your questions in the moment about election by acclamation. So as the screen clearly provides, the number of nominees doesn't exceed the number of seats to be filled, and one should say, well, that should be easy. 3 up, 3 in. But the California legislature had a different opinion on that, as they always do. So a few years ago, one of our communities that we represent, a 6,200 unit association, who had to spend $25,000 for each mailing, hired an advocate who also worked with CAI's advocate, CACM's advocate, and ECHO representatives to try and get the California legislature to say, okay, for the big associations where it is so expensive, let's make sure that they can do election by acclamation. And a new law was established that allowed for that, which really made life really great. And then everybody else got jealous and said, hey, we want that to apply to us as well. Small associations, if they have to spend $700, it is so expensive for them. And it seems wasteful. If you have 3 people that are interested for 3 spots, why have to go through this entire process? So the advocates for all the organizations got on board and really worked with the California legislature to allow for election by acclamation for all associations. And that's fantastic. One of the things that we need to be mindful of, however, is that some people think that this is just an administrative process, that it's not an actual election when you acclaim, oh, you're elected now to that position. As we're going to describe today, it isn't procedural exercise that you have to go through, but it really is an election, and the election is called election by acclamation. Unfortunately, the California legislature may have been just a little bit bored or in the mood to really micromanage. And so instead of carrying over the rights that were implemented for the 6,200 and greater associations, they added so many different provisions to this law that it has made it somewhat cost prohibitive to go through the acclamation process. It's not easy, but hopefully we will take you through the point by points so you understand the process and how we can deal with these requirements. I will tell you, we represent over 800 association clients throughout California, and we only have one who has successfully completed this process since the implementation of the new law. On the next slide, Connor, thank you. One of the requirements is that the directors must have been elected within the last 3 years. So you have to go through what we'll call a formal or regular election in order to get to the process and period of time in which you can actually proceed with an election by acclamation. So when we were preparing for today's topic, Stephen and I were talking about the actual words. Members must have been elected within the past 3 years. I'm sure even our attendees could have war stories about how many times we don't meet the quorum. And here we have associations that are going through the process, but they don't have the ability to meet quorum. So the election of new directors never happens. So what do we do when we deal with that issue of, did we actually go through and elect new directors? And we came away with the conclusion of we're going to do the best we can. We are going to make sure we follow all the requirements. We're going to make sure that we try to meet quorum for the election of the board. We're going to look to see whether associations have reduced quorum requirements. And if we do everything right, and if you speak with your association legal counsel, we're going to have the decision be attempting is good enough if you weren't able to accomplish it, because this is really one of the advantages of elections by acclamation, that we shouldn't have to go through this really arduous process of trying to meet quorum and go through that process. But as I mentioned a minute ago, the California legislature was bored, and so they added this process, and they require numerous what we'll call reminder notices to the owners. And the first is that 90 days before the deadline, you have to do a mailing and provide every owner with what they call this first notice of the number of vacancies to be filled, the deadline for submitting nominations, the manner in which the nominations can be made, including whether there can be self-nominations, and a statement where there's a deadline for the nominations, and of course, where those responses need to be sent. And so that's the first one in the process of the notice. So that's one mailing. I'm not all concerned about that one, because you have to do that mailing for a normal election anyway. But as Stephen will tell us on the next few slides, this becomes an arduous process and an expensive notification. Stephen?
Thank you, Sandra. So as Sandra was mentioning, it seems that the legislature's concern was individual homeowners being deprived somehow of their ability to elect board members. And so they added all of these requirements to remind people, hey, just so you know, if there's only these many candidates for these many seats, the board can seat them without having to go through a formal election. So speak now, or you can't complain later about the fact that you're not in the running or you're not on the board. So there's a reminder notice that has to be sent out again, at least 7, but not more than 30 days before the deadline for nominations for the call for candidates, telling everybody in the community, all the members, the same information that was in that first notice, plus the names of all of the qualified candidates who have been nominated or have self-nominated so far, so that somebody can say, hey, you know, Mary Sue is running for the board. I didn't realize that. You know, I would like to run for the board too, for that same seat. And so there's this second reminder notice that, you know, there are these many candidates, these many seats. If we don't get more than that, the board has the ability to seat those people by acclamation. And then Connor, next slide. Another requirement is that within 7 business days, not calendar days, the statute distinguishes between those two things. Each time the association receives a completed candidacy notice, they have to provide written or electronic receipt of that notice to the person who nominated that candidate, which is often going to be a self-nomination, as well as written or electronic notice to the person who has nominated them, that whether that nominee is either qualified or unqualified, and if they're unqualified, the reasons for which they're unqualified, and that they have the right to contest that disqualification by engaging in internal dispute resolution, whatever the association's process is for that. Again, because most of these nominations are going to be self-nominations, that same notice can be combined so that you can say, yes, we received the nomination, and okay, this person is qualified or they're not qualified, and all the other information that's required if they are not qualified. So there's a more formal process. And again, this isn't required of every election. It's required if an association wants to maintain the ability to eventually have an election by acclamation. So they have to provide these additional notices. And on the next slide, we talk a little bit about another requirement that this new process requires.
So the association permits all candidates to run if nominated, except for those that are disqualified from running as allowed under the election rules. If you don't know, and I'm sure if you don't, you'll be watching last year's video that was recorded webinar. But the statute changed very dramatically on qualifications for running for the board. The legislature thought that boards of directors were making it too difficult for people to run for the board, creating old boys or old girls clubs so that people were really kept from running, and that associations were using violations against board members to say they were not in good standing to keep them from running. So the legislature came up with this standard that you could have 4 permissive qualifications, such as not having committed a felony. No 2 persons running from the same household can serve on the board at the same time. And 1 statutory, which is you have to be a member for 1 year before you can run for the board. So the legislature said, okay, if, as it related to acclamation, we already have the authority to set this up so that we know what the qualifications are if we're going to run. If the association allows the candidates to run, except for those disqualified because they didn't follow and didn't meet the requirements that I just referenced, which can be in the association's election rules, or if it would exceed the term limits in the bylaws, then the association is a candidate for election by acclamation. I do want to state one thing about exceeding term limits. When the laws on the election rules that we referenced last year in our seminar were created by the legislature, they created a hole in the election law which really wiped out provisions in associations governing documents that had term limits. Needless to say, there was a lot of commentary about that by homeowners associations throughout the state. And the legislature went in and revised this piece of legislation that gave rise to the new election laws, saying that we didn't mean to do that, although they didn't acknowledge that as an error, but the intention was not to wipe out term limits in the bylaws. So that's not one of the qualifications that I referenced. So if you meet the timelines that we're talking about, and if we have the number of candidates that are running for the board and the number of candidates that can fill the spots on the board can vote to consider the qualified candidates as elected by acclamation. And so I'm clear, if there are 3 people running for 3 positions on the board and all the criteria has been made, then the board can consider those qualified candidates to have been elected by acclamation pursuant to a duly noticed meeting at an open session board meeting. And remember that phrase, because Stephen's going to be talking in a moment about what that means and can we do it elsewhere other than at an open session board meeting. And the answer for the cheaters, such as myself, who want to know the answer is yes, you can do it at the annual meeting. And we will be talking about that in a moment. It is important to understand that this is an actual election by acclamation. As I mentioned before, it's not just an administrative process. So we want to be mindful of that. So on the next slide, when we're evaluating when does the election by acclamation happen, we really have a number of questions that the board needs to consider. At what point should the board vote to approve the election by acclamation? Is it at the moment in time when the criteria is met? What time should the announcement be made to the community? Neither of those are specifically identified in the statute. And the issue is, should we do it as soon as the nominations are received and before the ballots are mailed out? Or should the vote happen on the date of the annual meeting? And we raised these questions because although we've been dealing with this law, we realized that here as well, we have a gap in what is stated in the statute. And so, Stephen, if you could take us through the answers to these questions so that the attendees really can see that there are options here. And frankly, these are difficult questions, but there are answers.
Thank you, Sandra. Yeah, the statute doesn't really say when the election by acclamation has to take place. It just says that the board, after it, the association has jumped through all these procedural hoops, can hold an open session board meeting and vote to seat those candidates elected by acclamation. So the question then becomes, well, when is that supposed to happen? So the most logical time would be after all the qualified candidates are known, and then after the deadline has expired for anybody who's been disqualified to engage in IDR, internal dispute resolution, with the board regarding their disqualification. And so that's going to be before the ballots get mailed out. That's even going to be before the 60-day pre-ballot notice, which SB 323 created, gets mailed out, which makes sense because the idea here is that we're going to save money, not have to go through the rigmarole of having an inspector conduct an election if we don't actually need to. And so that process it has to happen after we know who those candidates are. We know they're qualified, but before we've already prepared and mailed out all the balloting materials. So what that means is that could happen well in advance of the annual meeting, which then raises a question, which honestly hadn't occurred to us before we started considering this. But what happens when a director is already on the board? Their term extends all the way to the date of the annual meeting, but it's going to expire then. But then another candidate is elected by acclamation well in advance of the annual meeting, which doesn't usually happen. Usually those two dates sync up pretty well. And what we think the answer is that you're going to have these incumbent directors, kind of like you do with presidential elections, right? So, just like the national presidential election, we elect the president in November. That person is the president-elect for the next couple months, and then they are actually formally sworn in January. So you're going to have a similar situation here. If the association has done all the things it's required to do to conduct that election by acclamation, you could have somebody the board votes to elect that person by acclamation, but then they're not actually going to be sitting on the board, attending board meetings, receiving the agendas and the board packets and things like that, until a couple months later. Another thing that the statute doesn't address is when you're supposed to announce the results. There's already a requirement that for a regular election, quote unquote, where the members vote to elect the directors, that the association has to provide notice of the results within 15 days of the election. It doesn't say anything about elections by acclamation, but we think that it probably makes sense to just follow that same time frame because, like Sandra said, this is actually an election. It's not just some procedural exercise. So if that's the time frame that's required for conducting a regular election by the members, it would seem that the same requirement for announcing the results 15 days of that vote should be applicable. And so the statute leaves some questions open that there are some, we think, common sense answers to. Maybe in the next year or two, the legislature will clean it up a little bit. But right now, we think that's how we would address those things.
Excellent, Stephen. And I do want to say that I sort of have a cheat sheet for the board members that are in attendance, and that is when you sign your contracts with your independent inspectors of elections, the companies that will be handling the inspector obligations for the board, see if you can negotiate a two-tier fee from them. Because if you start this process and you are successful in being able to go through the acclamation process and they don't have to send out ballots and therefore don't have to count the ballots, you'd like to have to pay less for your services than if you were going through and having to do the full election, not by acclamation. So we want to really be mindful of that too. Look at this as a cost savings opportunity for the association. I'm not suggesting to nickel and dime our vendor. I'm suggesting that we just have a two-tier process if we are successful in not having to go through the balloting process, that would the association not actually be charged for that. So we have an incredible number of, and thank you for this, questions. We are going to go by the most upvotes. That's the policy for ECHO. I'll read some of the questions, Stephen. You can jump on them with your answers and I will answer them as well. And we'll start with the most upvotes. If using election by acclamation, how do you handle other questions like IRS tax resolutions?
Sandra, before you move on to your Q&A, I need to do one housekeeping chore, if I might.
Certainly.
Sure, I want to, so thank you so much. It's been great. But this Q&A session is sponsored by Liberty HOA Election Services and Silver Creek Association Management. Thank you so much to them for sponsoring it. Sorry to interrupt. Go ahead.
No, and I should have known that we wanted to do that shout out. We are so grateful for their sponsorship and allowing ECHO to put on these presentations. It's really amazing. So I thank them as well. Okay, if using election by acclamation, how do you handle other questions like IRS tax resolutions? So the first thing that I'd like to say about that is the IRS tax resolutions are conveniently done by annual meetings and through balloting, but they don't have to be done that way. And we are not saying that you're not going to have an annual meeting. You're just not going to have an election of the board where you're required to meet certain quorum requirements to open the ballots for an election, because you will have had election by acclamation. Stephen, is there anything on that question that you would like to add?
No, just that it's going to be a much shorter annual meeting than it would be otherwise, because you're not having to go through the formal process of electing the board. You're just going to have that resolution on the agenda. But yeah, that has to happen at the annual meeting, although the members are almost invariably going to agree that yes, the excess profits can be rolled over into the next year. The members are the ones who have to decide that. So that can happen at the annual meeting.
Excellent. All right, the next one is, let's see what we have here. If an association's bylaws allow nominations from the floor, can that association have an election by acclamation? And if allowed, would the process differ?
That is an excellent question. Nominations from the floor are allowed by a lot of associations' bylaws. They're not really consistent with the whole idea of having a secret ballot election. But I would say that if the election rules do repeat that same requirement for allowing a nomination by the floor, I don't think you could probably have an election by acclamation, because you might have somebody who shows up at the annual meeting or have someone nominate someone at the annual meeting, and then you would have more candidates than, well, potentially you might have the same number of candidates as open seats. And in that case, you could have an election by acclamation. But if you end up having more candidates, then I don't think you could.
And what happens if the election rules were drafted by our firm, where we would not carry that over if it wasn't part of the requirements requested by the board of directors when preparing the election rules? Would you then be able to go forward and do the election by acclamation, even if the nominations from the floor was allowed in the bylaws?
In that case, I would say, no, you would not have to do the nominations from the floor. The changes made by SB 323 are pretty clear that the election rules kind of control over anything else. So if you had a requirement for nominations from the floor in the bylaws that you then eliminated in your election rules, then that would be the controlling document.
All right, and I agree. All right, the next one, less nominees than openings. Less nominees than openings. Now what?
So in that case, I would say that the board could probably seat the qualified candidates and then appoint somebody else to the vacancy that's going to be created by the director whose term is expiring.
Absolutely agree with that answer. I think that's the best way to be able to move forward and allow the process actually to work. The next question, what should be done if an adequately signed petition for a special, we're going to save that one actually. That's a recall removal, and we will keep that one live for the next part of our session. In response to all the notice requirements, the question from Nicole Dillon Lee is, can the notices be emailed or do hard copies have to be mailed? Hard copies have to be mailed because the statute says that these are individual notices, and there, as an individual notice, the homeowner is required to get the archaic paper ballots. That's why it is so important to really try to go through this acclamation process to save the money that the association would be spending on those mailings. I told you earlier about our association that at 6,200 units went for acclamation and hired the advocate and really started the acclamation law. And they've spent $25,000 every time they had a mailing. $25,000. And they tried desperately to try and limit having to do that. And of course, they wound up with a piece of legislation. Now, this new legislation applies to that large association as well. So this is a zero-sum game. They're out of luck. They're doing these mailings, and it's costing them as much money. Anything else that you want to add to that, Stephen?
Well, just that the members can opt in to receiving notices by email, but the default rule is unless somebody has opted in, that notice has to be sent to them via first-class mail.
And so that it's an arduous task to keep track of who's opted in and who hasn't opted in. That works fine for smaller associations. It's more difficult for larger associations, but that doesn't mean that you are not going to keep track of it. It just requires more work. All right, next question. When you say members must have elected directors within the past 3 years, does this mean every third year you have to send ballots? Or is it the fourth year you have to send the ballots? You want to take that one, Stephen?
I would say 3 means 3. So, 3 calendar years starting from the date of the last annual meeting. So that the association within that 3-year period, at least once, has not done an election by acclamation, but has actually gone through the whole process of sending ballots out to the homeowners, doing the call for candidates beforehand and all the rest of that. So it would be a question I would say that you would want to ask your inspector first, but the inspector is always allowed to speak with the association's attorney on those types of matters.
So this question hasn't really circulated its way around all of the attorneys in the state. I agree with your answer, Stephen. I imagine some will say every 3 years. So please speak to your own attorneys, but we're going with every 4 years, assuming that everybody's doing their job. Next question. Hi, Sue. The annual meeting, how do we get quorum with no ballots? Do we try again and again? The reason that we have quorum requirements for the annual meeting is to open the ballots. If we're not opening the ballots, we don't have to have quorum for the annual meeting. That's my opinion. Stephen, would you agree?
I would agree, except that the homeowners can't conduct any other business at that meeting, which I guess would include the IRS resolution. You would need at least a quorum to do that. That's something that they can either approve on the written ballot or they can do it at the annual meeting. It's not one of those topics that has to be done via secret ballot.
Correct. Absolutely agree with you. How are business days calculated? Are reminder notices business or calendar days? We're talking about all of the reminder notices that we talked about, Stephen.
Business days are calculated per the civil code. There are pretty handy calculators that you can use online to calculate those. Usually excludes weekends and federal holidays, but that first quote unquote reminder notice and the second reminder notice where you're telling people, hey, by the way, if we only get as many nominations as there are open seats on the board, or there are going to be open seats on the board, those are business days, not calendar days, because the management office or the inspector, I should say, is going to have to actually be vetting the candidates as those nominations come in. And so they're allowed a certain number of days to do that. And so that's why it's business days as opposed to calendar days.
All right. Sarah asks, if there's more than one resignation and the board is too small, are there any exceptions to the 90-day rule? Any way to speed up the election process? In order to reach the acclamation election, the answer would be no.
Right. It's statutory.
All right. So the next question, I believe, has been answered. So we will go on to, can the board elect by acclamation some of the eligible candidates and make the other ones go through the balloting process? And the answer is no. This is one for all and all for one. Everybody has to be treated the same. Otherwise, I promise you, your election is going to be contested. Unless Stephen disagrees with that, we're going to keep going.
I agree.
Okay. What happens if you have 3 open positions and you have a tie? So if you have 3 open positions, in order to have acclamation, you have to have 3 candidates or less to go forward with the acclamation process. So I'm not sure you could have a tie. It wouldn't apply.
Right. A tie, implies that you're actually opening the ballots and tabulating them and things like that. With an election by acclamation, you're not doing that because you've already vetted all the candidates ahead of time. And the end result is by the end of the nomination process, we've got as many candidates as we have open seats. So you're not going to have a tie.
Exactly. So James asked a question, and thanks so much for paying attention, James, and trying to trip up the lawyers, but we're ready for this one. Stephen said that election rules control over the bylaws. How is that possible? And how does that square with Civil Code section 4205, which deals with the hierarchy of governing documents, putting rules below the bylaws? So what do you say about that, Stephen?
So that's a good question. It does come up a lot. And yes, you're right, James. This is a unusual exception to that hierarchy. Normally, any kind of board adopted rules are below the recorded documents or the bylaws. In this case, though, the Civil Code says that the qualifications for the board can be in the bylaws or in election operating rules. This is Civil Code 5105. So because that statute is very specific about the procedures for elections, the qualifications for service on the board, the qualifications for continuing service on the board, and that it says that those things can be in the bylaws or election rules, because the election rules are the later adopted document. They are going to control over the bylaws. It's unusual, but I think that's the general consensus among attorneys who've been working with the behemoth that SB 323 and all its progeny are over the last few years. So yes, this is an exception to that.
So I'm going to briefly go over a couple of more questions, and then we're going to try and answer some of these in the second Q&A session, our sponsored Q&A session, after we talk about our next segment. Jeffrey asked, can the HOA hired a third party to conduct their elections? Yes, please do. It will create a lot less grief in your life if the association uses a professional inspector of election. We think it's really important that we have that distance, and so does the California legislature. So I think what we're going to do is put a pin in these other excellent questions, because we want to make sure that we get to our materials. And we always reserve the right to have Dave interrupt us and say, hey, wait, what about this? I'm watching that as well. So how about if we keep going on to our next section, Connor? So recall elections. So some of you might say, I don't understand this. We are going through this recall process. We got a petition. It was signed by 5% of the owners, and I can't find it anywhere in the Davis-Sterling Act. And you're right, you won't, because it's governed by the Corporations Code, not the Davis-Sterling Act. I do want to say what we're going to be discussing now is not new law. It is recalls are actually recalls or removals. It's removing somebody from the board And that is really the appropriate way to describe this. We've all come up with the slang of calling it a recall election, and so we will do that for today's presentation. So it's not a new law, except for setting the date for the special meeting to comply with the SB 323 requirements. That was a new feature in the law. But because we're talking about elections and acclamation, we thought, as did ECHO, that this would really be a good topic for us. The corporations code, when we're talking about recall, removal of the board of directors, so we're talking about seated directors. And although we take the position that the election qualification provisions really apply to board members when they're seated as well, it's not as specifically worded in the Davis-Sterling Act. So when we're looking at recall elections, we know that the board can be recalled or removed for cause. That's really rare. It's usually because people don't like something that a board member is doing or board members are doing. So if they can be declared of unsound mind by a final court order. I frequently, every single month, get communications from board members that say, well, this guy is crazy, therefore we are not going to let him to stay on the board. It's like, no, that's not what the statute means. It means by court order, meaning the court has to make the determination if somebody is unsound mind and unable to sit on the board. I've been doing this for 30 years. I've gotten one court order in my entire career in representing many hundreds and thousands of associations. So hard to come by. The next one is a felony conviction. If somebody has been convicted of a felony under the Corporations Code, they can be recalled. And if allowed by the bylaws, failure to attend specified number of meetings. Stephen and I actually go round and round on this particular issue. And the reason that that is important is that can't be a qualification to be elected to the board because it hasn't happened yet. So this happens during the service while you're on the board. And can you be recalled for that? If it's in your bylaws, it could be one of the criteria. But remember, you don't have to have a reason to be recalled. You just have to have the vote of the owners or failure to meet required director qualifications. So make sure that you're aware of the fact that we have the qualification requirements in the election rules, and then we have the removal requirements in the Corporations Code so that you don't get tripped up on that very issue, which it's easy to do because I've been tripped up on that before. On the next slide, we'll talk about removal by the court. And really, it is very rare that this will happen. When does it happen? It happens for fraudulent or dishonest acts or gross abuse of authority or discretion. Gross abuse of authority or discretion. So we have an association where we had a board member that was a convicted felon for embezzlement. We had advised the board of directors that this could impair their insurability under the directors and officers liability insurance. But the board felt that this person brought so much credibility to the board and so much brain power that they decided, instead of petitioning the court for the removal of this person from the board who was elected by the members, they instead made him the association treasurer and gave him sole check signing authority. You could not make these things up. When they were at the $200,000 loss of dollars from their operating account was the moment they said, maybe we made the wrong decision, and proceeded to encourage him to resign, or they were going to proceed with the court order. Please be mindful of who is on the board. Never give one person just check signing authority on the board, and certainly not a convicted felon for embezzlement. Stephen? On the
Thank
next
you,
slide,
Sandra. Yes, so the part of the corporations code where you're 99.9% of the time going to be talking about a recall of the board or removal of one or more directors is 7222, which is the members actually voting to remove somebody from the board or removing the board as a whole, as opposed to the board or a court doing it, which have very high requirements. So the way this happens is that the members have the right to call for a special meeting for many different purposes, actually. But among those is to send a demand to the board to say, we demand that this person or all of the board members be removed. And that so that what they do is they present a corporate officer, which would be the president or the vice president or what have you, with a signed petition with their printed and signed names, demanding that. They don't have to provide a reason. They don't have to say it's because we think that she's doing a bad job. They don't have to say it's because we don't like the way the lawn looks. It doesn't have to be anything. It can just say, we, the members, hereby demand that the board set the date for a special meeting for us to vote on that. And that petition only needs to be signed by 5% of the association's members. So even if 95% of the people in the community think everything is just great, they love the job that the board is doing, they love everybody who's on the board, all you need is at least 5%, and now you've got this whole process going. The board has to review this petition to make sure that, number one, these people actually are owners in this community, and number two, that these signatures, if they have specimens of their signatures, match. And that's something they should always be doing, because we have seen abusive petitions where it's somebody who goes on a, say DocuSign and just generates a bunch of fake signatures. So you do want to vet this petition to make sure it's valid. But once the board receives that petition and they have determined, okay, this is a valid petition, it has been signed by at least 5% of the people in this community, then within 20 days of that, they have to select a date that's not fewer than 35 and not more than 150 days from the calendar days from the date that it received that petition. The vast majority of the time, the board's going to set that date way out in advance, so that they have time to, consider the matter, speak with counsel, hire an inspector of elections, send out a call for candidates, all the rest of that. So unless they, I guess, don't really want to be on the board, the vast majority of the time they're going to set the date out as long as possible. And that 150 days, it used to be 90 until SB 323 was passed. And because it creates these very long time frames for conducting an election, there was a conflict for a while between the Corporations Code and Davis Sterling as far as when that date was going to be. Now the legislature's confirmed that that is not more than 150 days.
so I think it's the first gift the legislature has given us in a very long time, being able to extend out that process. And boards use it very effectively to continue to keep their nose to the grindstone and really do the work of the board. And hopefully by the time the recall actually occurs, the election, that they are hopeful that the election will fail. So on the next slide, we talk about what do we have to do to go through this. This is an actual election, just like any other election. It's really unbelievable that 5% of the homeowners, which in some cases 1 or 2 people, can cause the association to go through the process. I have been asked frequently, what happens if somebody says, I don't want to be part of that anymore, I was wrong, or I was duped into this? There's no authority that says you can remove your name from the petition. We take the position that you can, and if the threshold is reduced to a number that's lower than 5%, that would be the only way that we would be able to stop going through the recall election process. There is some mailing requirements as well on our last slide, where we have 30 days before the close of nominations. Again, we have to send this out by individual notice. There is a way for a homeowner to say, I don't need that on paper, you can email me. So assuming they've given that notice, we will be able to communicate with them electronically, but they will need paper ballots anyway at the end when we're getting ready to send those ballots out and vote at the recall election and then the election of the new board members. At least 30 days before distributing the secret ballots through the notification period, we have to make sure that the owners are told when the date and time is when the ballots will need to be returned and where they need to be returned, and the date, time, and location of where the meeting will occur so that they have the opportunity to attend, and a list of all of the names of the candidates that will be on the ballot. So the ballots, when you're going through a recall petition, is you have all of the balloting for the recall. And if that recall is successful, then you go through the ballots again and you go through and count the votes for the election of the new boards if it is actually successful. So we are going to go into our Q&A after we hear from Dave. You had something you wanted to say, Dave? So
Yes, I do. And I want to say thank you again for such a stimulating segment here. This Q&A session is sponsored by Liberty HOA Election Services and Silver Creek Association Management. So thank you for that. Let's go on with the Q&A.
All right. So I'm going to start with the prize for the most humorous question. And so Marcia gave herself her upvote, but her question is, when I was talking about the board member who was embezzled, so we shouldn't appoint George Santos to our board. And I think that the answer to that is yes, that would be good and prudent on your part not to include him on the board. You want to take some of the questions, Stephen?
Sure. And I'm going to look instead of the most upvoted, the most recent, because some of the most upvoted ones are from the first half of the presentation. Although if we have time, we'll try to get to those too. Okay. So Catherine's question was, what can we do if we have an adequately signed petition to remove and replace directors and it's submitted to the board and it's ignored? This does happen. And boards obviously want to protect themselves. Directors want to protect themselves. And recalls are always tricky, and they put everybody who's supporting the board in a sort of difficult position because you're trying to remain agnostic about this whole thing. You're trying to say, we're just trying to help the corporation comply with its duties here. But the board reviewing the petition, determining that whether it's adequate or not, determining whether it's been signed by the required number of homeowners, and then setting the date for that, those are requirements of the corporation's code. It's not really up to the board to ignore it or not. I suspect that Catherine may be referring to a specific situation in her community, but we've seen this where the board says, well, there's all sorts of procedural issues that we might not want to consider this a valid petition. If you're on the board, you should really be checking with counsel about that because they're going to advise you whether you need to honor this petition or whether there are some sort of problems with it, so that you could say it's not valid for whatever reason. Chances are, if you've got enough people in your community who don't like the association or the board, they'll figure out what those procedural deficiencies are and they'll just submit another petition. But once the board receives that and they determine that it is valid, they do have to set the date for that. Cecil asks, if an election becomes contested after May, okay, so I think this is a election by acclamation question.
Yeah, I think we're going to have to do most upvotes because otherwise it's
okay.
For some reason it didn't sort.
Okay. Anonymous attendee says, our management company is not following the election rules to hold an election. They're circumventing deadlines and mailings to just one mailing. What do we do? That sounds like a specific question that I am not sure I'm going to be able to answer one way or another. I don't know if I have enough information to say that your management company is necessarily doing anything wrong. You know, I would say bring it up at homeowner forum, or you know, send a letter to the board, or put your concerns in writing and send them to management. There could be valid reasons why the election hasn't happened. Can the reminder notice be sent by email instead of US mail? Again, it depends on whether somebody has opted in to email. It'd be nice if we had an opt-out process instead of an opt-in one, since it is 2023 and almost everybody has email now. But right now, it's the default rule is US mail unless somebody has opted in to receiving individual or general notice via email.
Let's take Jeffrey's question. What are the requirements for third party conducting elections? They cannot be engaged in a contract with the association for any other services. That's one of the ways that management companies can no longer be in a position to conduct these elections, and why the association has to go third party. They have a requirement to review the governing documents, provide notification as to where all communications to the inspector of the election must be addressed, where all ballots must be mailed, and to validate both the recall petition and the owners who signed that petition, and validate that the ballots have been submitted by owners of the property entitled to vote at the election.
And all those requirements are in Civil Code 5110 with the inspector of elections, who that person can be, what their duties are. You know, we used to say that the statute says that a member can be an inspector of election as long as they're not on the board or running for the board or related to somebody who's running for the board. And we used to say there are so many things that are required of an inspector. We're not sure it's really a great idea, but I understand now that there are a lot of smaller associations with relatively low budgets that do use members as the inspector. And I think if the board is willing to authorize their attorney to spend maybe an hour talking to this person, explaining what's going to be expected of them, explaining what their duties are, that they can contact the attorney if they have questions during or before the process. You know, I think there are plenty of situations where a member could probably do that. But if you've got anything larger than a very small community, make life easier on yourself and just hire a professional inspector of elections, especially because they're going to be taking all of the liability if something goes wrong, and you know, having to redo it. And they're professionals, they do it all the time. So it's probably just smarter.
One of the questions from Tiffany is, do you think the legislature will reconsider the requirement that you can't enter into a contract for the inspector if you already have a contract for other services? And I think the answer is no. That's been brought up to the legislature, and they think that it creates too much of a conflict. They had some idea that there was some nefarious plan that management companies were interfering with the election process through the inspector of election, making sure that the existing boards stayed in place. And we're pretty involved in this industry. I've never seen anything like that. And so I really have no idea why the legislature really took that position. It started with one initial complaint. They only advised that they had 3, yet here we are 2.5 years later, and we're stuck with all of these laws creating all of these problems for our homeowners association. So I don't think it's going to happen anytime soon. Let's see here. I want to make sure. Here's a question. If the recall ballot includes the vote for new directors, then the recall election must be more than 90 days out, not 35, correct? Question mark. And the answer is yes, because we have to follow that process of first going through the recall timeline requirement and then the election requirement. And that is something that was not addressed in the legislation, but we look at them as separate voting periods and separate voting issues.
Right. And just to add to that, it is a 2-step process. First, did enough members actually vote in favor of having a recall or removing somebody from the board. If you don't satisfy that threshold, which when you have an association of fewer than 50 members is a majority, and if you have 50 or more, it's a majority of a quorum, then you don't have to go to step 2 of actually, looking at who people voted for to fill that seat, because that director wasn't removed, or that board wasn't removed. So, or if you don't get quorum, that happens too. You can get a petition of 5% of the members saying, we want to remove the board, we want to remove this director, and then once you count all the ballots, you don't even get quorum for it. So then you don't have to proceed there unless you've got some sort of requirement for a reduced quorum for the member meetings in your bylaws.
Somebody asked if we can recommend an inspector of election. We're very grateful for all of our affiliate members who support our chapter. We're very satisfied with the services that one of our sponsors, Liberty HOA Election Services, provides. We have other members of ECHO that are also inspectors of election. So please use those resources. We're so grateful to them for their participation. And this isn't a commercial. This is, I truly believe that the people who are, and their companies that are involved in the organization really are providing excellent services to their association clients. Jean asks, does a recall require 2 ballots, one to recall and one to elect? It can be done in 1 ballot. It's just in 2 parts. As I described earlier, first you go through the recall process. If that's successful, then you go through the ballot process to count the votes for the replacement board members if the other board members are actually recalled.
Cookie had a good question. Let's say the bylaws don't require the directors to attend a certain number of meetings. Can the board add that requirement to the election rules and say a director once elected to the board must attend a certain number of meetings, and if they don't, the board can remove them? So again, this is a bit of an open question here, whether the board can remove a duly elected director for failing to attend a certain number of meetings. Davis Sterling doesn't really address it. The Corporations Code does address it, and it says that a board can do that if it's in the bylaws, but it doesn't say anything about election rules. So because the Corporations Code specifically says bylaws, we think it needs to be in the bylaws if a board is going to do it at all, which if they're thinking of doing it, I would definitely want to run that by council first.
I agree. So Connor, I see that we are at how much time do we have left?
We have about 15 minutes left for questions.
Excellent. So we are going to continue on with some of these questions. Great questions, and I love the participation here. It's just, they're excellent questions. Let's see. When recall votes occur, does it require a majority of a quorum? And what is the required quorum? If election rules are silent on quorum, what prevails? I know you know the answer, Stephen. Do you want to take that one?
Election rules don't usually address quorum at all. It's in the bylaws, what that quorum requirement is. So that's the document that you want to be looking at.
And it's in the documents as opposed to a statutory requirement. Is that correct?
That's right. That's right. Quorum requirements for other types of things, say increases in assessments, that is addressed statutorily. But for the minimum number of votes that have to be cast for a member meeting to be valid, that's going to be addressed probably in your bylaws, possibly in your CC&Rs. One comment I just wanted to highlight, Charles said, isn't agreeing to serve as director at all an indication that somebody is of unsound mind and ought to be disqualified? It has to be by court order, unfortunately, but you know, I understand the sentiment sometimes. What if a board cannot, Maria asks, what if the board cannot find an inspector of election homeowner? Everyone that they ask refuses, and it refuses to pay for a third-party inspector, as they know it will be acclamation. We've never had more people than seats available. What can management do then? So unfortunately, management companies did a great job of conducting elections prior to 2020. But the legislature said no one who's under contract, including the management company, can be an inspector anymore. So you're going to have to find somebody who can be an inspector. If you don't want to pay for a professional inspector and you can't find anybody who's in the community who's willing to do it, the statute does say it can also be including but not limited to a volunteer poll worker with the county registrar of voters, a licensee of the California Board of Accountancy, a notary public. So, you know, you still have to have an inspector, at least for that first part of that process of receiving the nominations, reviewing them, determining whether that person's a member of the association, whether they're qualified or not qualified. So it may be worth giving a call to your local registrar of voters to see if they have anybody who might be available. You know, maybe a local community college, if you talk to the or a law school or a paralegal organization, you know, they know plenty of notaries that they could refer you to. You know, this person doesn't have to be a volunteer; they can be paid for their services. It's just that they can't be under.
I think that they're saying that the board of directors doesn't want to pay for a third party.
Yeah.
And that's the problem here specifically. Right. The bottom line is not doing that and not having either an uninterested homeowner who can't be running for the board, can't be currently on the board, and not have a member of their household running for the board of directors. You subject the association to somebody attacking the success of that election. And that's really the issue here. So possibly go back to your board of directors and say, hey, we're taking a real risk here that our election can be overturned by not following this really important statutory requirement.
Right, right. So, but you know, there are resources out there of people who do this sort of thing on a low or no cost basis that you might want to tap into if you can't get somebody in the community, unfortunately, to help.
Gus asks, if a board member is being recalled, can that board member run in the recall election? Absolutely. We find
Yes.
about 65 or 75% of the time, the entire board that has just been recalled gets reelected. And it's just mind-boggling to me, but it happens frequently. And it just means people really don't understand the process. They get caught in all of the minutia and drama of the recall process. And because if they did understand it completely, it's really unlikely they'd vote to recall them and then vote to elect them.
Right, right. As long as the director who's, you know, running to maintain their seat doesn't use association funds for campaigning, that they use that if they do any kind of campaigning, that they're using their own funds for that.
Excellent. Teresa asked two questions. I'll combine them together. How do you increase the number of your board members? You do it by an amendment to your bylaws. And what's the difference between a director and or president, vice president, and secretary treasurer? The president, vice president, secretary, and treasurer, they're all officers of the association, but every one of them are directors. Some associations have more directors than officers provisions, and they are deemed to be inspectors, they are deemed to be directors at large or board members at large. So same thing, don't worry about it, you're together. So Connor is telling us how to get to our most recent and go to the 140 timestamp. That should help us here. All right, thank you for that.
Cecil asks, if an election becomes contested after mailing the additional call for candidates, is it necessary to mail the reminder notice, or can we go straight to the pre-ballot notice? So I'm not sure what you mean by if it becomes contested. Do you mean whether there's more candidates than seats available? Because in that case, you're not going to be able to do an election by acclamation anyway. But otherwise, if you have the same or fewer candidates as qualified candidates as seats, then yeah, you do have to mail. And if you want to conduct an election of acclamation, there's that first reminder notice, and then there's the second reminder notice. You would only go to the pre-ballot notice, which is the 60-day, it's literally a 30-day notice that in 30 days we're going to be sending out the ballots. You'd only do that if you're not going to be conducting an election by acclamation. You're actually going to be going through with a regular election. Catherine says, as members become more ignorant, apathetic, whatever, and we belong to two associations, both of which have experienced dwindling numbers of attendees, and one of them which has reduced quorum requirements. Is it wise to continue to reduce quorum requirements rather than concentrating on better communication with members? So the members are the ones who decide whether they're going to adjourn the meeting for reduced quorum. Except for those statutory requirements of quorum for things like increases in assessments, there is no actual law that says that you even have to have a quorum requirement at all. And in fact, in your bylaws. And in fact, I would say the modern trend is that many associations get rid of quorum altogether. And so that way, no matter how many votes are submitted, that's the one, those are the votes that are going to count. And you don't have to go through this whole two-step process of, did we get quorum? And if yes, how did people vote? Or if we didn't get quorum, are we going to adjourn and do a reduced quorum? So that may be one way of dealing with that, is just the next time you amend and restate your governing documents, to speak with the attorney who's preparing that and say, what if we just got rid of quorum altogether, right? I would say that's something that we generally recommend for that very reason, that it's just a hassle for everyone involved to have to do these multiple meetings and, getting all geared up for it only to find out, oh, we didn't make quorum, so that could be a way of handling apathy in your community.
But of course, you'd have to go out to a vote of your members for that,
Right.
and they always think there's some nefarious plan by the board of directors to deprive them of their rights by going through that process. So I absolutely agree with your answer, Stephen, but the problem is homeowners think that there's something wrong there. That's a concern. Somebody asked who is responsible for validating the petition. When the petition comes in, the board or the managing agent will validate who is answering that, who is validating that petition, and then that petition will also be reviewed by the inspector of election. Let's see, next one.
Jean asks, oh, I'm sorry.
No, please go.
Jean asked, must all elections, regular or acclamation, be at the annual meeting? A regular election is going to be at the annual meeting because you have to provide notice to people of where the ballots are going to be open so that they can attend and watch the inspector open them, tabulate them, et cetera, et cetera. An acclamation, as we talked about earlier in the presentation, that's often going to happen well in advance of the annual meeting. And so you're going to have the board voting to seat qualified candidates even in advance of the expiration of the existing director's terms. So that doesn't necessarily have to happen at the annual meeting, and in fact is often going to happen in advance of it. Bruce asks, our HOA allows for write-in nominations from the floor during the annual meeting. Is this no longer valid? It's valid if your election rules allow for it. And again, many bylaws allow for write-ins, but then when an association prepares its SB 323 compliant election rules, they get rid of that requirement. Our position is that you can remove nominations from the floor and write-ins in your election rules, even if they're allowed in your bylaws. It's open for debate. Somebody could challenge it. Somebody could say, our bylaws say that this is our God-given right to write in candidates at the annual meeting. And you shouldn't have removed this requirement, but there's really no case law that's tested it. So many associations just decide to remove nominations from the floor and remove write-in candidates altogether because it's not really consistent with the whole idea of a secret ballot election. And also, how's the board supposed to determine whether somebody's qualified at the annual meeting while everybody's sitting there waiting for the votes to be counted? It just drags the process on even longer.
Absolutely. Marilyn asks, can an owner, where'd you go, Marilyn? You were here a second. Can an owner be given a second ballot if they lost theirs? Yes, some inspector of elections require you to affirm in writing that you lost your ballot before they will give you a replacement ballot. But yes, the ballot isn't voted until you voted and it's received by the inspector. So the answer is yes. Are there rules or guidelines for campaigning? There's some. The statute says that you cannot use association funds. If you are on a petition for being recalled and then you're running for the board, you cannot use association funds or association media to advocate for your retention on the board or election to the new board. If you do, you will activate something giving somebody the ability to have equal access, meaning that the people who are against you can demand equal access using association media and to contact the owners to advocate for the recall. What you can do individually as board members in not using association funds is to advocate for your retention on the board, therefore the failure of the recall petition, and and if that fails, your election on the second part of that ballot.
Anonymous attendee says, if a recall election results are going to come out at a time when homeowners don't have time to get those results before the annual election, can both ballots have the same list of candidates? I believe the general consensus is if you've got a recall election underway and then an intervening annual meeting with an election, it pretty much wipes the recall process out, because you know, how can you be voting to recall people when you're at the same time that you're also voting to put people on the board? So, you know, and sometimes when we send the notice to the community, we say, okay, we're going to have this recall election. We received this petition. It's signed by more than 5% of you. It's going to cost $5,000 to go out and hire, well, that's just a random number, but to go out and hire an inspector, print everything out, do the call for candidates, et cetera, et cetera. Oh, and by the way, we're also still having the annual meeting 2 months later, you know? So instead of costing us $5,000 to conduct these meetings, now it's going to cost you $10,000. Sometimes I'm not saying that people don't have the right to submit a petition if they want, but sometimes the homeowners say, you know what, maybe this isn't the best use of our assessments to be doing this. Maybe we should wait and see how the annual meeting turns out. Maybe I should run for the board, you know? So that's one way of handling that.
So Leslie Kassoff says, shockingly, I think, that her association has 24 units and one person can ask for board removal, and the association is required to go through the time and cost of process for one possible disgruntled owner. Yes, call the California legislature and tell them how insane that is, because I would agree that 5% causing the association to go through this process is really just an arduous task and an expensive task. Lynn asked, can an outside property manager send emails to members saying vote for incumbents and disregard the member campaign against recall ballots? I think that if the management company does that, they will likely be the former managing agent for the association. I don't think there's anything proper about that. If the new board was chosen by acclamation, let's see here, I'm sorry, I lost it. If the new board is chosen by acclamation and announced prior to the annual meeting, then what actually is the annual meeting about? The annual meeting is a members meeting, a meeting of the members for the business of the members. We discussed earlier that you would vote on the IRS rollover that does not have to be done by secret ballot. We just have gotten the habit of putting that on the secret ballot. So I think that it is important that we recognize there is a differential there. If the board is chosen by acclamation and announced prior to the actual meeting, same question twice. Okay, somebody put something in here that a website says that the association officers need not be directors as done in a corporation.
I have seen bylaws that say that before. You know, directors are elected by the members and then the directors themselves vote for the officers. It's not a great practice, but if the I can't think of a lot of reasons, unless you're talking about a developer controlled board, why you would want officers who are not directors also. But I would say if the board has the choice, they should probably be picking fellow directors as the corporate officers. Let's see. My friend.
Scott said, I missed the response when the board should announce and install and seated board elected by acclamation. Stephen went through that before and talked about you can do it right when you receive those ballots, letting your homeowners know that those people will not be seated until the current board's term is over, or you conduct that election, hold on to the ballots and hold on to the results, advise of the candidates and let them know that this will not be addressed until the annual meeting, if that's where the board chooses to have that discussion.
Right. Some of the questions are a little fact specific and seem to be addressing a specific situation as opposed to sort of in general. So I don't know if we can get to those, although if anybody wants to email us afterwards, we could talk to you about that. In a recall, what happens?
I'm noticing a question in the chat that Dave answered. Somebody said, if a board president wishes to be an ARC committee, is that okay? Dave correctly said, yes, a director can be on a board committee. However, be mindful of the fact that that could easily turn into a board meeting that will require notice of a board meeting if you wind up having three persons on the board at that committee meeting.
Right. Whatever the requirement would be for, let's say you've got a 5-person board. If you've got 3 directors on a committee, well, now you've got a board meeting. It's not just a committee meeting. So those types of committees, especially if they're advisory committees, try to keep the number of directors on them to less than a quorum.
Brian, or Stephen, we're just about out of time here. So
okay.
Last question, we'll go from there.
Okay. Let's see. Can the management company handle the election duties up to allowing the inspector of election to count the ballots? So the inspector's job is not just to count the ballots. It's also all the other things that are listed in Civil Code 5110, determining how many people or members are allowed to vote, what their voting power is, reviewing proxies, receiving the ballots, receiving, hearing, determining any challenges. So because those are all things that the inspector has to do, and the inspector cannot be somebody who's under contract with the association, no, I would say the management company cannot do those things.
I agree. Dave, turning it over to you.
Thank you so much. I want to say thank you to Stephen Brindle and Sandra Gottlieb from Swedelson Gottlieb. What a wonderful presentation. Thank you so much for doing this again. You're so clear to help this sound so simple. And it's not. So good. So I want to say thank you also to all the ECHO members for coming today and supporting our ECHO webinars. For those of you who are not ECHO members, we invite you to become a member. You can join by simply going to our website, www.echo-ca.org, and clicking on the membership tab. We have both individual and community-wide memberships, so your entire community can join if your board so chooses. For our members, please invite your friends, boards, and especially management firms and vendors to participate and join ECHO. If you value what ECHO offers, we humbly ask you, our loyal members, to help us grow. In 2023, ECHO plans to hold more than 70 events, 3 in-person educational seminars, and more than 30 in-person webinars, it should be. Further, ECHO is celebrating its 50th anniversary, and we have special activities planned throughout the year, including a grand anniversary celebration scheduled for Friday, May 5th. That's Cinco de Mayo. We will be sending registration information about this event to in the next few weeks. Please be on the lookout for it. We hope to see all our ECHO members at the 50th anniversary celebration. If you have some time and would like to help Echo, we have a few opportunities available for you. Please refer to the slide and contact me if you see anything that might interest you. Some of these are paid part-time positions and some of them are just volunteer. Now for the announcements. Our next Echo in-person event is going to be January 25th, when the East Bay Resource Panel and the newly formed Echo Club at Rossmore will meet at the Fairway Room at the Creekside Clubhouse in Walnut Creek. The topic is maintenance and reserve funding studies. We are currently sold out, but if you would like to be added to the waiting list, contact Connor. Please, not our upcoming meetings. Please, our upcoming meeting on the slide. They are, you can see the slides, I'm sorry. They are also found on our website. So if you want to take a look at our upcoming meetings, they're on the slide and on the website. We invite any HOA board members or former board members to join the Echo HOA Board Members Club. This unique club meets on every second Tuesday of the month from 5:30 to 7 p.m. Except for this February. It turns out that February 14th is the second Tuesday of the month, and a few people said they had to go out on dates, so we aren't having it on Valentine's Day. So
People have their priorities mixed up.
yeah, that's right. Well, they have them right in my book, but we did move it to the 16th, and it's going to be kind of an interesting meeting. And please join us if you are a member of Echo and you are a board member, a former board member. Our next meeting is going to be Who's My Favorite? A conversation about outstanding performers, and we'll have our award nominations. So we hope that you come and talk. We're going to be giving out awards at our centennial, and we're asking people to join the selection committee as well. If interested, please contact Connor at echo-ca.org. Once again, I want to say thank you to our sponsors who made this webinar possible, and to all of you for attending today. Echo appreciates your investment in education to build better HOA communities